The 10 things to do before you die. We have with us today attorney Mark Ostraw, who is a copyright and entertainment attorney. He's the chair of Romano Law's music industry practice. He represents songwriters, recording artists, labels, music publishers, authors, and other creatives, as well as the businesses that produce and license intellectual property. He has been recognized by his peers as a 2022 New York super lawyer for entertainment and sports law, and has been rated AV preeminent by Martindale-Hubbell. He's got more than 30 years experience as an executive, as an attorney, both in-house and private practice, all within the music industry. He ran the New York office of the London-based classical music publisher Boosey and Hawkes, which represents many of the greatest composers of the 20th and 21st centuries. He was a senior attorney with BMI, where he was prosecuting and defending all kinds of music actions. And he also is an adjunct professor at Cardozo School of Law, which happens to be my alma mater. So that's always exciting to see that they've got the quality of Mark coming in there to teach. I believe it's actually one of the top schools for music law as well. So that's
Billboard ranks it #1.
Grants it #1, and I'm sure that's partially, at least mostly, due to you, people like you coming in there. He's been interviewed, across television, Fox, Scripps TV, Court TV, News Nation, lots of symposiums, lots of talks. He's a couple panels this week. He's paneled out, but we managed to eke one more out of him. He was a former trustee of the Copyright Society of the USA and has served on the boards of the New York chapter of the Association of Independent Music Publishers and Music Publishers Association. He's a pianist. He's a musician in his own right. So welcome, Mark. Thank you for joining us and sharing our wisdom. A few other things that I must say before Mark speaks is that this is a general conversation. It's intended for a general audience. Mark is not your lawyer. He is simply providing his point of view. He's also not a trust and estates attorney, so keep that in mind too. We have a Q&A. You can ask him any kind of questions that you'd like. He's extraordinarily smart and knowledgeable in these areas, and he's definitely available if you want to make him your attorney, and that is a separate matter that you can take up with him later on. For now, I will remove my box from here, and I will pass the baton over to Mark.
Thank you very much, Deborah. Thank you for that kind introduction, and I'm glad to be with you all this evening. As Deborah mentioned, I am not a trusts and estates lawyer. I am a copyright and entertainment lawyer with a focus in the music business. And Deborah invited me to speak with you this evening because she had read my blog post, which I will share the screen, and we're largely going to be walking through this, and I'll be providing additional comments about it. And that is, of course, the post, estate planning for composers and songwriters, 10 things to do before you die. So as I mentioned, I will be largely tracking this post, and I'm going to copy this and put it in the chat. Hopefully that'll show up, so any of you who want to look at the post, and I'm trying to get this back up where I can do it. Pardon me for a second. Well, it doesn't seem to be working. Okay. I'm gonna stop the share for a second so I can actually get to the chat. And there it is. Okay, so go back to the share screen. And let us begin. So the most important thing, whether you're a songwriter, composer, dramatist, poet, whatever kind of creative you are, is to organize your files. And what does that mean? So anything related to your creative work you want to have organized, whether it's in a file cabinet with paper files or organized in file folders on your hard drive, and whether you save it on a thumb drive or in the cloud. You want to make sure that all of your contracts with all of the entities that are representing your works are in one place. You want to keep copies of the most recent royalty statements, so that anybody who is going to be taking over the administration of your creative work has an idea of what these works have earned in the last few years before you passed. You want to have any assignments of any royalties, any assignments of rights. All these important documents should be kept together. Everything should be clearly labeled. If nothing else, that is the most important thing that you should do. And if nothing else, that will certainly help your loved ones and your executor of your estate tremendously. So for those of you who do write music and are composers, this would include files for your performing rights organization, whether you belong to ASCAP, BMI, SAC, or GMR. If you operate through a furnishing company, and I will be spending a little bit more time at various points in our discussion this evening about furnishing companies, and surely many of you do business for your creative work through either an LLC or an S Corp. So you want to make sure that you have those documents readily available. And if your furnishing company has more than one member or shareholder, for example, you may be in a writing partnership and formed an LLC. You may have an LLC with your partner or spouse. Whatever the situation is, if you have a corporation or an LLC that is your furnishing company, you want to check what the bylaws or operating agreement says about what happens when a member or shareholder passes. You want to make sure that that is current with your wishes, and if any interests in your furnishing company transfer automatically to the surviving member, if it's possible, and under what circumstances can interests in your furnishing company be transferred or sold, and what consents the surviving member may have. So you want to make sure all of that is taken care of, and that's separate and apart from your will, which is one reason why we're discussing it this evening. So very often, whether you're a songwriter, composer, or playwright, you may have your works represented by more than one publisher or other entity. Sometimes you may be, especially in the music business, you may be self-published. So, for example, if you have retained your copyrights and you have your own personal publishing company, you want to make sure that whatever agreement you have with your administrating publisher, that's readily available as well. So keep all of those things handy. And especially if your works are represented by other entities, all the contracts for all the people that represent and license or otherwise exploit or pay royalties with respect to your creative work, those should all be in one place, clearly labeled. Now, let's talk about copyright registrations, for example. There are all sorts of reasons, as we'll discuss, to register your works with the Copyright Office if you haven't done so. Agreements with collaborators. One thing that you should always have is written agreements with your collaborators. For example, I have written a blog post that's on the Romano Law site called Copyright Conundrums for Collaborators. And one of the things that people don't realize when they are dealing with what we call joint works is how the off-the-rack rules under the Copyright Act operate. So, for example, let's say that Deborah and I write a song together, and I solely write the music, and Deborah solely writes the lyrics, and we intend to collaborate to create a song. Who owns what? Some people may think, well, I own the music and Deborah owns the lyrics. That's actually wrong. I own 50% of the music and the lyrics, regardless of the fact that I only contributed to the music. And Deborah owns 50% of the lyrics and the music, regardless that she only contributed just the lyrics. Copyright is a form of what's known as intellectual property or intangible property, and the principles for IP are descended from principles for physical property, in particular real property. So let's change the hypothetical. Let's say Deborah and I buy a house together. It's not that I own the front yard and she owns the backyard, and I own the upstairs and she owns the downstairs. We both own a 50% undivided interest in the entire house. The egg is broken and scrambled, and you can't put it back together again. So what the Copyright Act also says is for each joint owner of work, in the absence of a written agreement, the ownership rights are in proportion to the number of writers. So if there are 2 writers, it's 50-50. If it's 3 writers, it's a third, a third, a third, regardless of the prominence of the writer and the nature of the contribution. If you want to alter that, and if you want to say that, for example, in the absence of a written agreement, any joint author can issue non-exclusive licenses subject to the right to of the other party to get compensation for their fair share. So let's say Deborah and I want to make sure that both parties have to give their permission. That has to be in a written agreement. Let's say that she's far more prominent a writer than I am. If it's off the rack, it's 50-50 split. If we want to alter that, it has to be in a written agreement that says Deborah gets 75% of the copyright ownership and the royalties, and I only get 25%. And so those agreements should be entered into. In music land, we typically call it a split sheet. Collaboration agreements with creators of musicals, for example, and operas are usually far more complex, but you should keep them together. Recording contracts, licenses, if you have digital files, you should organize those too. For those of you who write music, your Sibelius finale or Darko files and PDFs of your scores and sheet music and audio files all should be clearly labeled. If you write plays, for example, let's say you write screenplays and use Final Draft, all of that should be clearly labeled. Create an easily accessible master list for your usernames and passwords. So make sure people, let's say you organize your files and label them beautifully, but nobody can get into your computer. That's going to be a problem. So, and let's say you organize everything beautifully and you have you have your ASCAP or BMI affiliation agreement, or you have your Dramatist Guild management agreement, but somebody needs to be able to get into your online account. You have to keep the passwords handy for your PR, for any licensing entity and publishers where you have online access to their portal. You need to keep those written down where somebody can access them. So again, for songwriters and composers, you want to make sure that your works are registered with your performing rights organization. For most of you, that would be ASCAP or BMI, and with the Music Licensing Collective. For those of you who don't know what the Music Licensing Collective is, that was created under the Music Modernization Act, and that entity exists for one purpose and one purpose only, and that is to license the mechanical license for the server copies for streaming services. And so you have to register your work separately with that to get royalties for those uses. Number 4 is something that people don't necessarily think about. Make sure you assign the copyrights in your works to your furnishing company if it's a corporate entity, a corporation, or an LLC. For example, if you are a songwriter and you register your works with ASCAP and you register the publisher's share in the name of your LLC, ASCAP will pay your LLC. ASCAP and BMI and a lot of these other licensing collectives, they only track payees. They don't track ownership. Under the copyright laws, transfers of ownership in nearly all cases have to be done by a written agreement. So simply because you form Jane Doe Music Publishing Company or Jane Doe Furnishing Company for your plays, for example, that doesn't mean, and even if you register Jane Doe Furnishing Company with ASCAP or BMI or with any collective that licenses your works, let's say you have musicals and plays registered with MTI or Samuel French or something like that, they'll pay the royalties, but that doesn't mean that those works, whether they're individual songs, whether individual plays, or your respective interest, if you are collaborating, is automatically in your corporate entity. They have to be assigned. If, for example, they're not assigned, technically under the copyright law, copyright vests, meaning as soon as copyright is created, it belongs to the creator unless it's a work for hire. So if you are an individual songwriter or playwright, and as soon as you finish it, you don't have to register with the Copyright Office, but there are reasons why you should, which we'll get to in a minute. Those works belong to you personally. They don't automatically go to your furnishing company. So what you typically would need to do is create a short form, 1-paragraph assignment of copyright with a Schedule A listing the works, and sign in one part as the assignor yourself individually, and as the assignee on behalf of your furnishing company accepting the assignment. And then the works are actually in your furnishing company. Why is this important? Because if you want them to be in your furnishing company, and if there's documentation in your bylaws or operating agreement as to how these assets are distributed upon your passing, if you're a sole member or if you're a member in a multi-member LLC or shareholder corporation. But again, I'm not a trust and estates lawyer. Check with your trust and estates lawyer. Some of that may very well be outside the scope of the probate estate. If it's not properly assigned, it becomes personal property. Copyrights are treated as personal property, like your tables and chairs and cars, etc. And they're lumped in together with your personal property. So you want to make sure that is taken care of. I am aware of a situation where a fairly prominent composer had registered the composer's works with the PRO. In this case, it happened to have been ASCAP, and had a furnishing company, but the composer passed away unexpectedly, and the works were not assigned to the LLC furnishing company, and it became a mess. If you learn nothing else today, make sure you organize your works, and if you're operating through a furnishing company and you want your works represented by the furnishing company, they have to be assigned. You should register your works with the Copyright Office. Again, registration is permissive rather than mandatory. Under US law, as soon as a work is fixed in a tangible medium, as soon as you put the pen down, as soon as you hit save, as soon as you hit print, you have a copyright. And I've written a blog post, which I can also put in the chat, 6 reasons why you should register your copyright with the Copyright Office. So I've done that now. So let's go back to the share screen. And there's a whole host of reasons why you should register. Of course, it's kind of like a deed to your work. It provides evidence of the work and when it was created. It's the best evidence for what the work is and when you wrote it, because as part of the copyright registration process, you have to provide a deposit copy of the work with the Copyright Office. But the most important reason to register is if anybody infringes your copyright, if somebody rips you off, if you think somebody is taking your copyrighted work and creating a derivative work of it, or using characters that you created, and you want to sue the bastards, unless you have registered with the Copyright Office, you can't file a lawsuit. Section 411 of the Copyright Act says that you have to register prior to filing a lawsuit. There are some exceptions for foreign authors, but for those of us who are US authors creating works in the United States, you got to register. The third reason is there are certain remedies under the Copyright Act. For example, there's something called statutory damages, which are much easier to get than trying to figure out actual damages, the infringer's profits and your losses. It's often hard to calculate, and those damages are often fairly nominal. Statutory damages are not available, and you can't, and under the Copyright Act, the prevailing party in an infringement action can, but not is guaranteed that the court will award the attorney's fees. But unless you register the works prior to the infringement taking place, you can't get statutory damages or attorney's fees. How do you know when you're going to be infringed? You don't. So that's an important incentive to registering your works with the Copyright Office. So let's go back to things to do before you die. Make a list of works that's represented by other publishers. We've kind of covered this under point 1. It can be a Word document. It could be an Excel spreadsheet. I'm used to primarily working with composers and songwriters, although I certainly represent book writers and playwrights as well. But the columns can be, the title of the work, the instrumentation, the publisher's name, contact information. If it's playwright, if it's a musical or a play, the title of the work. You may want to put the approximate duration and the dramatis personae. Certainly, if it's represented by a publisher, you want to have that. You want to have that handy. So all of this is basically common sense, and time permitting, we can talk about more reasons why you should register your works with the Copyright Office. But let's move on to point 7. Let somebody know where all this information is kept. Master list and instructions should be kept in a separate document and kept with your will. It shouldn't be necessarily part of your will. And one thing that I can tell you that's not in the blog post here is first of all, if you have your will, and you should have a will, and you should work with a qualified trust and estates attorney in your jurisdiction, because trust and estates law, unlike copyright law, is a matter of state law, not federal law, and laws vary from state to state. So keep this someplace, but don't keep it in a safety deposit box. Do not keep your will, and do not keep these lists, these important lists that we've been talking about for the last 20 plus minutes, in a safety deposit box. Why shouldn't you keep it in a safety deposit box? If you don't already know, again, laws vary from state to state. I happen to know this firsthand because my mother recently passed earlier this year. And fortunately, because my father had passed 2 years prior, we were aware of what happens in New York, for example, upon somebody passing. Even if that safety deposit box, and in the case of my parents, first of all, the deposit box was in the name of both of my parents. And then when my father passed, my mother changed it to in the name of herself and one of my siblings. Even if somebody else who's still alive is listed as a signatory on that box and has a key to that box, under New York law, and check the law in your jurisdiction, that box gets sealed upon the financial institution where the box is held, learning of the passing of somebody whose name is on that box. So technically, my sibling, who happened to be the executor of my mother's will, would not have been able to get anything out of that box until the will was probated, and my sibling as executor happened to be my brother, until my brother was named executor of my mother's will, and under New York law got what is called letters testamentary, which means that he can open a bank account in the name of the estate, get a tax ID in the name of the estate, and start to do business to distribute the assets under my mother's will on behalf of the estate and the beneficiaries. How long does it take to get letters testamentary in New York? I'll just give you one anecdotal example with my mother. She passed at the beginning of April this year, and she had a will which was submitted to the court a couple of weeks later. It took 5 months for the court to get around to the application to issue letters testamentary to my brother. You don't want all this valuable information stuck in a safety deposit box for a number of months, including the will. First of all, if the will's in the safety deposit box and that's the only copy, you can't even apply in New York to get the will probated because you're stuck in this legal limbo, which will be a heck of a time to sort out to get access to the will when the safety deposit box has been sealed. So make sure you consider that, and don't, keep jewelry and things in a safety deposit box, but don't keep your will and don't keep the stuff related to your will in that safety deposit box. Deeds and things like that, yes, absolutely. But the will and all this information that relates to the administration of your estate, that shouldn't be in the safety deposit box. So, of course, it's Trust and Estates Week, and for those of you who have been attending other seminars this week that the Dramatists Guild has been putting on, get yourself a good trust and estates lawyer. As I mentioned, Copyright law is a matter of federal law, but trusts and estates are basically governed by state law, and every jurisdiction is different. So you want to meet with a trust and estates lawyer about drafting important documents, such as your will, your living will, healthcare proxies, all that good stuff. And certainly, as with your documents related to your creative property, don't keep your living will and your healthcare proxy in a safety deposit box for all the obvious reasons that I just mentioned. So very important to work with a trust and estates lawyer. Some trust and estates lawyers, particularly in parts of the country like New York and California and Tennessee because of Nashville and Music City, you will find trust and estates lawyers that will know hopefully more than a little bit about intellectual property and creative properties, whether they're songs, compositions, plays, novels, etc. However, they're not going to know all the intricacies that an entertainment lawyer with a background in IP would know. So for that reason, you should also consider working with an entertainment lawyer in conjunction with your trust and estates lawyer. And as I mentioned in the blog post, there are many who are well versed in copyright and the entertainment business, but most, especially if you're not living in an area that's a big arts hub, if you're in Iowa or Wyoming, it's less likely that you're going to find a trust and estates lawyer who is versed in these issues. But there are other reasons, and this is not just a sales pitch to hire either me or another qualified entertainment lawyer, but for those of you who are in the business of creating creative works, whether it's songs, orchestral compositions, plays, musicals, an experienced music or entertainment lawyer can provide valuable assistance. One thing is there will be, or there should be, specific provisions in the will as to how you want to divide up those assets to your beneficiaries. As I mentioned before, in the absence of spelling out specific bequests with respect to your IP will be treated as personal property and will be lumped together with your residual estate, with your personal property, unless you specifically delineate how certain things you want them to be distributed. And that is not necessarily how creative people want to have their legacy carried on, just having it lumped together with everything else. So an entertainment lawyer who is versed in IP can assist your trust and estates lawyer in drafting specific provisions in your will that deal with your creative properties. To the extent that those of you who are watching this presentation this evening, to the extent that you are songwriters or composers or work with songwriters, composers on your projects, such as musicals, most trust and estates lawyers won't know about submitting registrations with ASCAP and BMI and making sure that new works are properly registered with publishers, if your works have been recorded on record labels to make sure you get mechanical licenses. All of these things, it would be helpful to have somebody who's knowledgeable in the area of the creative industries that you're in, work with your trust and estates lawyer on these issues. What happens typically is once somebody at, say, ASCAP or BMI learns that somebody has passed, things get placed on hold unless and until the heirs to the decedent's interest come forward and also register with the performing rights organization ASCAP or BMI to get that writer's share. Otherwise, they just sit in the black box, and depending upon the state that you're in, if nobody comes forward after a certain period of time, the laws of abandoned property or escheat kick in, and in New York, that property would default to New York, that income would default to New York State. So you certainly don't want that to happen. You want to make sure that whoever is in charge of your estate knows to get the people, the entities that are paying royalties, to get your heirs properly registered with these entities so that royalties can continue to be paid. Determine whether royalties are properly being paid or may be terminated either through contractual provisions or through the termination provisions of the Copyright Act. Some agreements book publishing agreements, for example, will have reversions. Say that if the book is out of print for a certain period of time, the rights revert back to the author. Well, if the author is deceased, those rights would revert back to the heirs, but the heirs have to know about this. Again, make sure you have your contracts where where somebody who is dealing with your estate, your executor, will be able to find them, so that any contractual reversions can be dealt with. Before we started our program this evening, I was talking with Deborah about the termination provisions of the Copyright Act. And these provisions basically provide the authors or their heirs a second bite at the apple. For works written prior to 1978, the applicable provision of the Copyright Act is Section 304C, for those of you who are copyright nerds and want to look this up at copyright.gov. For most works written, for works written since 1978, which I suspect would be most, if not all of you on the Zoom this evening, that would be Section 203 of the Copyright Act. These provisions are very, very similar, but not identical. And basically what they say, the policy behind them, for those of you who are not familiar with the termination provisions, is that very early on in a creative person's career, whether it's a playwright or a novelist or a songwriter, they don't know what their own work may be worth down the road. They have limited, if any, bargaining power with respect to the publishing house that they're dealing with. So they may sign a contract that is not terribly favorable. 35 years after you sign that contract, and typically if you assign your copyright in whole or in part, there are these provisions, the termination provisions, that allow you to serve a notice on the party that the author or the heirs, and the heirs are specified in these termination provisions. And these termination provisions, the heirs in the termination provisions trump the heirs specified in the will. Again, supremacy clause of the Constitution, federal law trumps state law. So for example, even if you as an author cut a child or a spouse out of your will, putting aside the surviving spouse elective share, let's say you cut a child out of your will, that child will still have a termination interest under the Federal Copyright Act termination provisions if you pass during the applicable termination window, which starts for a 5-year window starting basically 35 years after you assign your copyright to a publisher or a music publisher or something like that. So you have to be aware of those provisions. They are designed to be difficult to execute because there was a lot of lobbying done, and certainly the book publishers and music publishers and other copyright owners had more lobbying power in Congress than individual authors and songwriters. So that's another reason why you want to work with an entertainment lawyer who knows IP, who knows the Copyright Act, to make sure that whoever is administering your estate is aware of the possibility of these termination provisions, and that to the extent that they are exercised during the administration of the estate, that they're done properly. So one of the things that I mentioned to Deborah before we started the panel today is there's a recent development that's been going on that harkens back to what I was discussing earlier today. Remember how I told you that you should assign your copyrights to your furnishing company if you're operating through a furnishing company? Well, publishers and music publishers don't like being terminated and having their rights taken away from them. So and the Copyright Act is very specific that the grantor of the rights or their statutory heirs, and it specifically talks about surviving spouse and children, has the right to exercise the termination rights. And what these entities have been saying is, okay, 35 years have passed, you served a termination notice, and let's say the author has passed, and you are the children collectively signing a termination notice to a music publisher or a book publisher. But the creator, the author, operated through a furnishing company, and the contract between the publisher was with the author's furnishing company. Well, that grant can't, they're making the argument that that grant can't be terminated because it wasn't the grant of the author, it was the grant of the furnishing company. Cases right now are being litigated. I can't tell you as we sit here this evening whether that argument is going to fly or not, but it is something to consider. You know, whether you may want to revisit operating through a furnishing company. I have a feeling that even if the courts decide that this kind of loophole to avoid termination is valid, assuming Congress ever elects a new speaker, if this happens, probably Congress will step in and amend the termination provisions to say, no, that defeats the intent of these termination provisions, and we want authors, even those who function through a furnishing company, because that's the way the industry typically works, is we want that to be able to those terminations to be able to be effective. So that's something to watch out for in the next few years, how that plays out. But termination rights under the Copyright Act are very important and can be very valuable. You can send a termination notice and then renegotiate a new deal for the terminated entity to buy back those rights. Or you can have them go to a new entity after the effective date of the termination. This is something that frequently needs to happen with respect to estates and with respect to any taxes. You may need an entertainment lawyer to assist in appraising the value of your creative works, especially if the works under the will are to be sold, or your heirs want to sell them. Parallel with that is entertainment lawyers can help negotiate sale or administration of your works. Let's say, for example, that your works, you handle the administration of your works yourself, and you either want a music publisher to administer on your behalf and you as the heirs retain your rights, or you want the Dramatists Guild to do that for you. While I am sure that the contract that the Dramatists Guild Rights Management is fair and reasonable, you may want to have peace of mind and have an entertainment lawyer look it over just in case to make sure. Another thing that you may want to consider is having a separate music or arts executor. And the point is the person who you trust to deal with your home and your most valuable possessions and keepsakes on behalf of your loved ones may not be the best person or knowledgeable about your creative work. Again, I originally wrote this post with respect to songwriters and composers, and I used the example that, you know, this person who is your general executor may not know, for example, did you really mean to put that C sharp in the horn part in this work? Similarly, if you have an unpublished play that is not completely finished, how do you want it to be released? Under what circumstances do you want it released? Who do you want to be able to complete it if you want it completed? These are reasons to possibly have a separate arts executor. And it doesn't have to be a lawyer. It can be a colleague who's also an author, hopefully, judged by the likelihood of people passing, probably you want somebody younger than you significantly, a colleague, and say, I want my son to be the executor of my will, but for my literary or artistic properties, I want my friend Jane to be my literary or music or artistic executor, and that person will work in conjunction with my executor to make the decisions. So those are some of the considerations that you should take into account. So we've now gone through the article that I posted. It's in the chat. You should certainly feel free to look at it at your leisure, along with the copyright registration post. But there are a couple other things that I wanted to mention before taking a few questions. And I already spoke about terminations and the issue of furnishing companies. And I just briefly touched on, what about your unpublished or incomplete manuscripts? You probably want to have let's see, you probably want to have somebody deal with that, or you want to have something about that in your will. So that's something that you want to look into. Another thing that I didn't mention in the blog post and haven't mentioned yet is, for those of you who are not just authors, whether it's writing songs or writing plays or what have you, but are also public figures who are performers, who are presenters, you have rights in your name, image, and likeness. And so the right of publicity comes into play. And again, unlike the Copyright Act, the right of publicity is a creature of state law, and the laws vary from state to state, including whether and to what extent the right of publicity extends after the figure's death. So you certainly want to have your trust and estates lawyer be aware of those issues, to the extent that you are also, in addition to a playwright, if you're also an actor, if you have done film and television or that sort of thing, if you have publicity rights to be exploited, that's something that you want to address. And finally, before we take some questions, the hot topic right now for anyone in the creative fields is AI. And just as the Writers Guild has addressed these issues, and SAG-AFTRA is attempting to address these issues, you may want to address these issues in your will. To what extent that it's not otherwise covered by any of these guilds that you may or may not be a member of. And again, if you are someone who is also a performer, you may want to say, I authorize the use of AI versions of my name, image, likeness, etc., under certain circumstances. Or you may want to just have an out-and-out prohibition. No way, Jose, I don't want an AI clone of me being exploited. And again, to the extent that you have unfinished works or even completed works, any sequels of works, any unfinished works, to what extent do you want or not want to have AI involved? At this point, it may be something to consider to put into your will. So that's pretty much what I have to go through with you all this evening. And so to the extent that we have some questions and we have some time left, I'm happy to answer them.
And I would encourage you to take advantage of that. It's not every day you get to sit in a room with a attorney and ask questions. So the first question we had is in the example of your family, and again, I'm sorry for your loss. If your brother had the power of attorney for your mother, would he have been able to get to the safety deposit box before receiving the letters testamentary?
That is an excellent question. My brother was named the executor of the will. I had a power of attorney for my mother. The problem is the power of attorney expires upon the death of the person who you have the power of attorney for. So no, even with a power of attorney, once the person passes, that power of attorney expires, certainly under New York law. I can't vouch for under every jurisdiction, but I suspect that in most jurisdictions, the power of attorney would expire upon the passing of the person who granted the power of attorney.
So the message is just don't put it in a safety deposit box.
Well, don't put it in a safety deposit box, but we did have advance warning that my mom was ill. So when she went through her final illness, and since I was a signatory on the safety deposit box, I cleared the thing out prior to her passing.
Wow.
So,
wow. So the next question is, there are so many new innovations in music. How do I best protect my work when I have no idea what's ahead?
That's a good question. And the simple kind of glib answer is, you can't predict the future. You don't know. Who could have predicted even a year or two ago all the advances with generative AI? So again, another reason to have an arts executor to provide guidance for what you might want to the extent that you can guess what may be coming down the road, or at least have somebody who's knowledgeable about your work and knowledgeable about the industry in which you are a creative person to make informed decisions as best they can. So I see another question. If you name a beneficiary with ASCAP, do you still need a will? Absolutely, yes. Because ASCAP, for those of you who are songwriters, ASCAP only represents one thing. They represent the public performing right in musical compositions. So if you are a songwriter, yes, ASCAP will pay your public performing rights, but that doesn't mean you'll get your mechanical royalties from the record labels. If you're also a recording artist, that doesn't mean you'll get your artist royalties. That doesn't mean that anybody has the right to license your works. It just means that you'll get that one income stream from ASCAP. It's a good thing to do to name a beneficiary so you don't have to worry about that one income stream. And as I was saying to Deborah before we got on this evening, in the music publishing pie, public performance, especially when you put in streaming, is about 70% of a songwriter's income. So it's important to name a beneficiary, but it does not fully protect you.
I see a question from Tom. Tom, I'm going to unmute you so you can ask your question since your hand is raised. Let's see if this will work. So I think you're unmuted. Oh, you have to unmute yourself.
Hi, Tom. What's your question?
Yeah, I missed the first 10 minutes. I'm sorry if you've already dealt with this, but I have other property in a trust, regular stuff, and I've heard two different opinions about whether you should assign or put your copyrights into a trust or treat it separately as in the will.
That again, one of the things that you missed in the first 10 minutes is, I'm not a trust and estates lawyer. I'm an entertainment and IP lawyer. So what I would do is, every circumstance is different. That's something that you should discuss with your trust and estates lawyer. Of course, anything that is in a trust typically is outside of the probate. So there are certain advantages of putting it in a trust. On the other hand, if you have other intellectual property that's under the will and some that's in trust, may or may not be a good thing, and I certainly can't opine on any tax consequences versus having it in a trust versus having it as part of your probate estate.
I can talk about this just a little bit based on what we talked about yesterday. And of course, all these panels will be on our YouTube channel. So I would invite you to see what various attorneys say. There are some different opinions. One of the big things you have to think about when putting your property into trust is the reversion, the termination rights that Mark was talking about. When they pass through will, they will pass along with however you've assigned it. When they pass through trust, the reversion rights will stay with the heirs. So that's one big debate that comes out versus trust versus wills. But yeah, definitely, you're welcome to reach out to us and we'll try to talk you through it a little bit, but your personal attorney is going to be the one to answer that question. Yeah. Okay. Does anyone else have any questions? Last chance. Oh, maybe one more. Oh, okay.
Twice. What do we got?
We've got one more. My husband has passed away. He made no legal arrangements for any of his creative work, including a musical for which he wrote the script in collaboration with a musician who wrote the music. None of this material was copyrighted or noted in his will, as his surviving spouse wanting to honor his legacy with a future production. In addition to trying to contact the musician or her daughter, what should I be doing to protect the work at this point?
Ooh, so let me see if I heard everything. So the person's late husband wrote this in collaboration with another creator.
Right. So her husband wrote the book of the musical, and then there was a musician who wrote the music. I'm not sure who wrote the lyrics.
In the absence, and that's why I mentioned joint works. In the absence of a written agreement, the two collaborators each own 50% of the copyright, music, lyrics, book, everything. So one thing that you should do is you can do a copyright registration for the work, naming whoever is the heir. And if we're talking about a surviving spouse, under most laws, the surviving spouse inherits everything in the absence of a will. Some states, it may be divided between the surviving spouse and any children. Check your jurisdiction. But you can do a copyright registration naming whoever inherits the deceased husband's share, and also whoever owns the other half of that share as both authors and copyright claimants. You can't claim the whole thing, but you can do a copyright registration. And to the extent that this work is in a position to be exploited, you should contact entities such as Concord Music has bought a lot of these rights companies up. The Rodgers and Hammerstein organization, a few others, or contact the Dramatist Guild and see how they might be able to assist.
Yeah, for sure. Mark, all of your blog posts are available through Romano Law website.
That's correct.
So I know people are eager to get them. So I reposted them again, but you could also check the website. And what if they want to reach out to you for some help down the line? The best way to do that?
The best way to is the contact page on the Romano Law website, and just say you want to talk to me, and the people who handle the intake will happily put you through.
Perfect. All right. Thank you so much.